First, want to remind you, as you just heard, that we are recording this panel, and your presence here is consent to being filmed and the use of your appearance in connection with this event. Our fourth and final panel today is titled Which History? Originalist Debates in Incorporation. And it is seeking to answer the question, how should originalists interpret the Bill of Rights after its incorporation? Some scholars argue courts should continue to look to the founding era, while others argue that the incorporation of the Bill of Rights warrants a new understanding, rooted in public understandings from the Reconstruction era. This important debate was referenced but not decided by the court in Bruin. Professors Kurt Lash and Julia Mahoney are going to share their views on this debate and how our fundamental freedoms ought to be interpreted post-incorporation. The panel is going to be moderated by UVA 1L and member of the Symposium Committee, Juliana Kantner, and she's going to introduce our speakers. Please join me in welcoming them.
Professor Kurt Lash is the E. Calbourne Robbins Distinguished Chair in Law at the University of Richmond School of Law, where he teaches and writes about constitutional law. Founder and director of the Richmond program on the American Constitution, Professor Lash has published widely on the subjects of constitutional law and constitutional history, including publishing books on the First, Ninth, and 14th Amendments. An elected member of the American Law Institute, Professor Lash's work has appeared in numerous legal journals, including the Stanford Law Journal, Georgetown Law Journal, Virginia Law Review, and Notre Dame Law Review. He has been a visiting professor at Northwestern University School of Law and is the former director of the University of Illinois College of Law program in Constitutional Theory, History, and Law. He is a graduate of Whitman College and Yale Law School. Next, we'll hear from Professor Julia Mahoney. Professor Mahoney is the John S. Battle Professor of Law at the University of Virginia School of Law, where she teaches courses in property, constitutional law, government finance, and nonprofit organizations. A graduate of the Yale Law School and a member of the American Law Institute, she is also taught at the University of Southern California Law School and the University of Chicago Law School. Her scholarly articles include works on eminent domain, regulatory takings, land preservation, healthcare reform, and property rights and human biological materials. Last spring, she was awarded our chapter's Paul G. Mahoney Award, which recognizes commitment to the Federalist Society's founding principles, excellence in scholarship, and support of our student chapter. Let's give one more round of applause for our speakers.
That's right, that's right.
Now we'll begin with Professor Lash's discussion.
All right, thank you, Juliana. Make sure that we got this close enough. Thank you so much for inviting me. It's been a great morning of panels. Especially excited to be a part of this, obviously most interesting of all the panels that we've had here today on incorporation. My thanks to the Federalist Society, and I'm very pleased to be on the panel with Julia. I want Juliana. I'm looking forward to you keeping us in line, and but also engaging in the conversation. I also want to take the chance to thank the Virginia Law Review for their help on my forthcoming piece, Becoming the Bill of Rights, the first 10 amendments from founding to Reconstruction. They're working on it. It should be out, momentarily. And they've been doing some great work with some very difficult historical sources. And that article that I'm publishing here with Virginia it works in tandem with a second article that I've just published with the Indiana Law Review titled Re-Speaking the Bill of Rights, A New Doctrine of Incorporation. And that article explores how the opening sentences of the 14th Amendment both modified and extended the original Bill of Rights, both against the states and also against the federal government. So these two recent pieces present an originalist theory of incorporation that I think actually can help us solve a number of rather difficult puzzles associated with the idea of incorporating the Bill of Rights. So in the time I have, I'm going to try to explain what I think the problems are that are facing originalists and why I think a new theory of incorporation can help us sort of bring coherence to this particular area. Okay, so three problems that originalists need to deal with when it comes to incorporation. First, does the 14th Amendment incorporate the Bill of Rights against the states? Okay. Second, if it does, do we enforce the 1791 understanding of the Bill of Rights or the 1868 understanding of the Bill of Rights against the states? Third, if we apply the 1868 understanding of the Bill of Rights against the states, do we apply that same updated understanding against the federal government, so-called reverse incorporation? Now, if you take a bifurcated approach to this issue, it would mean that we would apply a different understanding of the bill depending upon whether or not we're enforcing it against the states or against the federal government. If you're enforcing the bill against the federal government as an originalist, maybe you would apply the 1791 understanding of the bill, but then you'd have the same tax incorporated against the states, but you would apply a completely different understanding, one that's based upon the 1868 understanding of those same terms. If you take a unitary approach to incorporation, you would apply the same meaning against both the states and the federal government. And in my article, Respeaking the Bill of Rights, I argue in favor of that last approach. I believe that the people of 1868 entrenched a new category of constitutional rights called privileges or immunities of citizens of the United States, and that this category of rights is the same, whether applied against the federal government or against the state governments. The basic argument is that when the people adopted those opening sentences of Section 1, they effectively redeclared or respoke the Bill of Rights and invested those older words with new understandings. Again, understandings that apply to all government institutions. So those are the basic questions, and that's my basic answer. And so now I want to dig in just a little deeper to each one of these questions, because I think they build on one another and inexorably lead to a unitary approach. First, the first question, does the 14th Amendment incorporate the Bill of Rights against the states? We've had decades of scholarly dispute all the way back into the 20th century on this one. I think at this point that the pro-incorporation position has prevailed. Most scholars and judges, I think, accept the historical legitimacy of applying the Bill of Rights against the states by way of the 14th Amendment, whether it's by way of the Due Process Clause or the Privileges or Immunities Clause. The basic idea of incorporation seems to be taken as a given by most scholars in this particular area, and I think all of the justices on the current Supreme Court. Now, I need to give a shout out to Elon Werman at Arizona State. He continues to challenge the idea that the evidence supports incorporation, and he's taken a lot of guff for taking that position, and I welcome his work because he does good historical research, and I think he's keeping us on our toes. So I'm glad he's keeping us honest. Nevertheless, I still continue to believe, and I think most people believe, that the historical evidence gives solid support to the idea of incorporation in general. So what about the second question? Should we interpret these incorporated rights according to their 1791 meaning or their 1868 meaning? And here there remains substantial scholarly dispute. Some scholars insist that incorporated rights should be read according to their original 1791 understanding. I think that's the basic proposition of Judd Campbell in his work on freedom of speech. It's been the longstanding approach of San Diego Steve Smith in regard to the religion clauses. I think it's because Justice Thomas thinks that the Establishment Clause maintains its 1791 Federalist understanding that he resists its incorporation against the states. So there are those who are still calling for a 1791 incorporated meaning. I respect those views, but in my work, I think they fail to adequately engage the historical debates about the Bill of Rights that occurred between the founding and the Civil War. The people of 1791 viewed the words of the first 10 amendments through the lens of federalism and a desire to constrain the federal government. The people of 1868, however, viewed those same words through the lens of abolitionism and decades of struggle against slavery's denial of fundamental rights. Inflammatory speech in the 1790s was viewed as appropriately left to local majoritarian control. Inflammatory speech in 1868 was viewed through the lens of Southern suppression of inflammatory abolitionist speech and was viewed as needing to be protected. Prior to Reconstruction, the idea of a black American having an individual right to keep and bear arms for self-defense was an idea shared only by the most radical of abolitionists. After the Civil War, this was Republican orthodoxy. In short, I think that our national conception of enumerated rights in the bill changed dramatically between the time of the founding and the Civil War. And that decades of struggle over American freedom, I think, not only changed people's perception and understanding of the individual words of each of the 10 provisions in the Bill of Rights, I think that that struggle actually produced a new and transformed meaning of the entire bill. My forthcoming article in the Virginia Law Review documents this evolved understanding of the entire bill called the Bill of Rights. As Gerard Magliocca pointed out a while back, the original 10 amendments do not come with a label. They are not called or officially titled the Bill of Rights. Over the early decades of the antebellum period, however, Americans began to view those amendments not as a list of individual components, but as a unified document that declared a principle of American freedom, something which they increasingly called our Bill of Rights. Between the founding and the Civil War, people stopped viewing that bill as a statement of federalism and began looking to it as a declaration of liberty. By 1866, Americans, both North and South, routinely referred to the Federal Bill of Rights as declaring rights that should be protected by both the national and the state governments. Northern abolitionists, of course, in particular, insisted that states must enforce the Bill of Rights. Although free exercise of religion and freedom of speech might have been originally thought to preserve local majoritarian values, abolitionist Republicans now cited those same words as representing the right to disrupt local majoritarian values. Northern opponents of slavery insisted on the right to engage in inflammatory calls for slave emancipation, and they called for individual resistance to local enforcement of the fugitive slave laws. Madison and Jefferson would have been appalled. But this was no longer Madison and Jefferson's Bill of Rights. This was now the Republican, the abolitionist Bill of Rights. And it was their understanding of that bill that informed the public's understanding of the privileges and immunities of American citizenship that Republicans enshrined in the 14th Amendment. That brings us to the third question. If I'm right, and if the 14th Amendment not only incorporated the Bill of Rights against the states, but incorporated an 1868 understanding of the Bill of Rights against the states, where does that leave the original Bill of Rights? Do we enforce the 1791 understanding with dealing with the federal government, or an 1868 meaning, and a different 1868 meaning when dealing with the states? And the answer, I've argued, lies in the opening sentence of the 14th Amendment, not the Privileges or Immunities Clause. I mean the Citizenship Clause. The opening sentence of Section 1 declares, quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." This 1868 declaration announced something new under the constitutional sun. The original Constitution did not contain a clause defining national citizenship. It neither defined national citizenship nor declared whether that citizenship was attended by any rights, privileges, or immunities at all. This omission became a matter of substantial debate during the antebellum period and, of course, was one of the central issues in the infamous decision in Dred Scott against Sanford. When the people of 1868 constitutionally, for the first time, constitutionally defined the citizens of the United States, they not only buried Taney's opinion in Dred Scott, they also spoke into being a citizenship that they understood included certain national privileges or immunities. They then addressed that specifically in the second sentence. The second sentence declares that no state shall abridge these national privileges or immunities of national citizenship. And this means that sentence 1 and sentence 2 work in tandem. The privileges and immunities of national citizenship that are secured by the first sentence are then protected against state abridgment by the second sentence. However you define the rights of national citizenship, it is the same rights that are referred to in Section 1 that are then applied against the states in the second sentence. If the people of 1868 had a certain understanding of national privileges or immunities that they believed ought to be or must be respected by the states, then again, as a matter of text, this means that the people of 1868 believed that these same rights had to be respected by the national government for any person who met the new constitutional definition of a national citizen. But another way, if the people of 1868 believed states had to respect their particular understanding of the Bill of Rights, then this means that they believe the national government already was obligated to respect that particular understanding of the Bill of Rights, but they entrenched that through the adoption of an opening sentence. This unitary understanding does more than simply justify an 1868 understanding of incorporated rights. It also places the seemingly ahistorical theory of reverse incorporation, which has also got a lot of guff over time. It places that theory on solid textual and historical ground. There's nothing historically backward about allowing the people of 1868 to update the meaning of their enumerated rights. And the sovereign people who did this included women's rights groups, abolitionists, black sailors and soldiers, formerly enslaved black Americans, and pro-freedom Northern Republicans. I think their voices are worth hearing and are worth enforcing against all levels of government. Thank you.
Thank you. Thank you very much for organizing this conference and for including me. As the final speaker of the day, I will take advantage of my position to open up the conversation and to ask broader questions about the uses of history in constitutional interpretation in general, along with addressing some of the important issues concerning the Bill of Rights in particular. What we now call the Bill of Rights, as you all know, was added to the U.S. Constitution in 1791. And very quickly, disputes arose about whether, and if so, how, and to what extent, the provisions of these first 8 amendments to the Constitution bound the states. Opinions differed. William Rawle, in A View of the Constitution of the United States, argued that most of the Bill of Rights applied to the United States, to the states, not the 6th or 7th amendments, but most of them. Others, of course, disagreed. In 1833, the United States Supreme Court weighed in a case called Barron v. Baltimore, and answered the question, no. The Bill of Rights applies to the federal government and binds the federal government. And interestingly, in his opinion for the court, Chief Justice John Marshall invoked history, not the post-ratification history of Chief Justice Marshall's opinion in McCulloch v. Maryland. When addressing the constitutionality of the Bank of the United States, he looked to practice after the adoption of the U.S. Constitution. John Marshall's history in Barron v. Baltimore, stating that this question of whether or not the Bill of Rights, whether or not, in particular the Fifth Amendment, bound the state governments, he said, this question presented is, we think, of great importance, but not of much difficulty. The issue in Barron v. Baltimore concerned a wharf. Barron had been co-owner of an extensive and highly productive wharf in the eastern section of Baltimore, which enjoyed, or so we are told, the deepest water in the harbor, at least at the time that the wharf was acquired. And the city of Baltimore, using its authority over the harbor, ended up, in effect, directing waters away from the wharf, leading to the wharf no longer enjoying the deepest water in the harbor. This, argued the wharf owner, was a violation of the Fifth Amendment, in effect, a taking of property. Barron argued that this came within that clause of the Fifth Amendment of the Constitution, which inhibits the taking of private property for public use without compensation. The Fifth Amendment, being in favor of the liberty of the citizen, Barron argued, ought to be so construed as to constrain the legislative power of a state, the state of Maryland, as well as that of the United States. And Chief Justice John Marshall says, absolutely not. This is an easy question. Well, how does John Marshall know? He knows because he was there. Writing toward the end of his long tenure as Chief Justice of the United States in 1833, John Marshall was to die in 1835. Marshall had been born in 1755, and he had been, in essence, present at the creation of the new Constitution. And he said quite firmly that the Constitution was ordained and established by the people of the United States for themselves, for their own government, not for the government of the individual states. Each state established a constitution for itself, and in that constitution provided such limitations and restrictions on the powers of its particular government as its judgment dictated. So, Marshall says, it is universally understood, and as part of the history, that the great revolution which established the Constitution of the United States was not effected without immense opposition. Serious fears were expressed, Marshall notes, and he's correct about this, during the ratification process of the U.S. Constitution, that the federal government being created by the new Constitution was simply too powerful. It is not that it was denied that the federal government needed to have some extensive powers. After all, the United States was a new nation strung out along the Atlantic seaboard, surrounded by three great and rapacious European empires. But it was dangerous, or so many argued, for the federal government to have such powers. So serious fears were extensively entertained that those powers which the patriot statesmen, who then watched over the interests of our country, deemed essential to union and the attainment of those invaluable objects for which union was sought, might be exercised in a manner dangerous to liberty. In just about every convention by which the Constitution was ratified, there were concerns expressed, and so the Bill of Rights was in essence promised, or additional protections were promised. So John Marshall, history was essential, and it was history as a methodology, as memory. Now, of course, John Marshall died in 1835, and the memories of those who then were called upon to interpret the Constitution did not interpret actual exposure to the debates of the original Constitution. Barron v. Baltimore settled, for a time anyway, whether the Bill of Rights was to be applied to the state governments, but it did not settle whether the Bill of Rights ought to be applied to the state governments. Those discussions continued in the run-up to the Civil War, and of course they came to the fore in the aftermath of the Civil War. And they, of course, continued throughout the 19th and 20th centuries, and they remain with us today, because, of course, not all the Bill of Rights has yet been incorporated against the state governments. Also continuing have been ferocious battles over the use of history in constitutional interpretation. Yes, history is important. Yes, history can be illuminating, but history can also be misused. After the Dred Scott decision, and of course in two of the famous dissents in Dred Scott, the history of the majority of the Supreme Court was ferociously criticized. They have simply gotten it wrong, argued dissenting justices. And it is interesting to note that criticisms of the use of history have been present throughout the Supreme Court's history, and very importantly, were levied against the Warren Court. In a very famous article in the Supreme Court Review, published in 1965, Alfred H. Kelly wrote in Clio and the Court, an illicit love affair, agreed against what he saw as, in effect, use by Supreme Court justices of history, cherry-picking, law office history, he called it. In effect, if not illegitimate, if not completely unprincipled, at least the sort of use of history that was open to abuse. This is ugly, this is bad. And yes, he was talking about the Warren Court. The Warren Court, which one doesn't normally associate, or which, at least as memories have faded, the Warren Court's sometimes aggressive use of history, maybe cherry-picking, at least in the eyes of its critics, has faded a bit from memory. But the idea that history, that the use of history could be a powerful tool in the hands of judges who don't want to be constrained was first and foremost very prominent in this article, and Clio and the Court found a receptive audience. Those criticisms, those fears have, I would say, not diminished, because the fact is that history is very, very difficult to constrain. Now, when we look around how history is actually used now, by interpreters, and we might call them too constructors of the Constitution, I think we see history used in three ways. The first is history as authority, the second is history as guidance, and the third is history as inspiration. So first, history as authority. This is where most of the action is. It's where Professor Lash, I would say, works, Professor Elon Werman, Randy Barnett, and Evan Bernick, many, many other distinguished scholars, in effect, invoke history as authority. In effect, there are right answers and wrong answers when it comes to interpreting and constructing the Constitution, or at least answers that we can say with a high degree of confidence are better and worse. How are we to find them? We find them by careful examination of the historical record. We find them maybe up to a point by analogy to the extent that the record is not present, although there is, I think, a lot of hesitation and suspicion about the use of analogy in this, when history is invoked as authority. Analogy is already getting a little bit dangerous, or at least a little bit shaky, in terms of delivering the two things that the use of history as authority attempts to deliver. The first is answers, actual usable answers, as opposed to what we might call not in good faith, right, opportunistic uses of history to shore up conclusions, convictions that the arguer has already arrived at. And the second is constraint of judges and justices. History as authority, perhaps wrongly, has been at least defended, at least billed as being an effective, or at least compared to other methodologies, a more effective, other tools, a more effective means of constraining judges and justices. Now, when thinking about history as authority, I'm certainly not against it. I have produced some myself, and I am certainly a very respectful and grateful consumer of a great deal of this scholarship. But I do think it's very, very important to remain realistic about what history as authority can deliver to us. I am, I think, on balance, less optimistic than Professor Lash about the specificity of the answers that it can provide. And as evidence of this claim, I point to this extraordinary record of historical scholarship produced by Professor Lash and Professor Werman and Professors Barnett, and on, and Professor
How
Barnett.
many trees have died?
And so, okay, exactly. And here are people, and I have not even begun to exhaust the list, who I believe are writing in good faith, who are not, in effect, trawling through the archives in search of support for some pre-existing agenda, who really do want to get it right. And yet, we end up with a lot of really, really hard questions. And the disagreements are not minor. Oh, yes, I should add Christopher Green and John Harrison, and on and on and on. And the disagreements are not minor. Now, to me, this doesn't mean that the undertaking is not worth doing, not in the least. But it does mean that I am skeptical that we are going to get as much from it as many justices and scholars hope to get from it. Second thing that I think we need to be realistic about, or I would argue we should try to be realistic about when thinking about history used as authority, is its force to constrain judges and justices. I think that most judges and justices are operating in good faith. I do not think that they are political hacks. I do not think that they are, in effect, deceitful, up to no good, et cetera, et cetera. I think that most of the time, do their best. But history is not necessarily going to constrain. And when we look at John Marshall's use of history, whether he's invoking post-ratification history in McCulloch v. Maryland, or whether he's invoking his own memory of what everyone agrees was going on in Barron v. Baltimore, or maybe also Hunter's anyway, many cases that Marshall decides, note that it didn't satisfy people. There were already accusations that, in effect, Marshall was remembering wrong, or he wasn't perhaps being entirely honest, and so on and so forth. So history did not, I think it is fair to say, constrain John Marshall, and I don't think it constrains judges and justices all that much today. What I think constrains them is their oath of office and their attempts to do the right thing. I think history also constrains, perhaps not as much as it is generally recognized in my second category of the use of history, which is history as guidance. Very often courts are called upon to give content to important phrases that are not susceptible to easy definition. Coercion was mentioned by Judge Larson just now. There's also corruption. Corruption had a broader definition at the time of the founding, maybe probably a narrower definition at the time of the adoption of the 14th Amendment, interestingly, in general. And courts have to try to figure out what these terms mean, and history can provide, I think, very important guidance. We don't even need analogies. Although analogies can be very useful, we need to think about what was going on. We need to think about what the problems were that were faced by the founders, faced by those who crafted, ratified, implemented the 14th Amendment. Think about, of course, other constitutional provisions too. Our focus today has been on incorporation of the Bill of Rights, but I certainly don't mean to limit my comments. I think that there are many provisions of the Constitution where incorporation and reverse incorporation remain extremely difficult and very, very important issues. A reverse incorporation of the Contracts Clause, or what I would call a de facto reverse incorporation of the Contracts Clause, I think is important. And history, I think, can provide guidance. These terms that we have to understand, coercion, corruption, and so forth. If we're turning to one of my areas of specialty, property rights, understanding that the protection of property rights was important in part because it was kind of an anti-oligarchy measure. It was a way of ensuring that there would be an electorate that enjoyed some independence from potential pressure from government. I think all those can shed enormous light on exactly how to interpret and construct the Constitution. And I think, again, they do constrain to the extent that judges and justices take their oaths of office seriously and are attempting to do the right thing. The fact that terms are there's open texture to terms does not mean that their interpretation is an invitation to judicial misbehavior or judicial inattention. Finally, I want to mention history as inspiration, because we are, in interpreting and implementing the United States Constitution, we are part of a larger project, and we are part of a project that has not been completed yet. The Constitution, by its own terms, allows for amendment, contemplates amendment, was never expected to be done, and our founding documents themselves are one of aspiration. And I think when considering how to amend the Constitution, how to interpret the Constitution, it behooves us to not forget history and to think about the biggest and most grand intentions of the Constitution. Don't forget the preamble in particular, to establish a more perfect union, and don't forget the Declaration of Independence, which I think sheds light on the Constitution to the degree that the Constitution was, in a crucial way, meant to implement, give effect, give practical effect to the goals of the Declaration of Independence. And with that, I think I have run out of time, so we'll turn it over, and I look forward to your questions and comments.
Thank you both so much for your comments. I'd like to actually start by talking about something that you just ended on, and how we ought to be realistic about the specificity of answers that history can provide us. So I want to ask Professor Lash if and why you might feel that history can give you information that allows you to be confident in your answer about what the incorporation of the Bill of Rights means as they apply to the states and the federal government. And Professor Mahoney, if maybe you have any doubts as to where history may be ambiguous as it relates to this issue, and to kind of tie all of those things together.
You me to go first? Great questions. And Julia, wonderful presentation. I agree with all of the different uses of history. And on different Tuesdays, I agree with your skepticism. Not today, but on different, they're perfectly, absolutely reasonable, and originalists need to give an answer, or at least begin to build an answer to those questions. I especially like your point about history as inspiration, and I hope I have a chance to get to that. But first, I want to be responsive to the idea of, I claim to be an originalist. That means that I believe not only is it possible to make relevant discoveries about original meaning, but I also take the normative step of claiming that once we discover original meaning, we ought to use that meaning in a meaningfully constraining way in interpreting and applying the Constitution. So it places a big burden on originalists to support their arguments is driven by history. And here's this big debate over incorporation. Julia's right that this debate over incorporation has gone on. Before I entered the academy, some of you probably have studied this. Justice Black, right in Adamson, talked about, in dissenting in Adamson, he, against California, he said we should look to the Privileges or Immunities Clause and not the Due Process Clause, and he cited John Bingham, and he thought he had a good historical argument. That led to an explosion of a scholarly debate between Charles Fairman, Fairman and Burgert, who all was involved, Krosky, and just books and articles going back and forth over the question of incorporation. By the time I entered the academy in the 1990s, a major book by Michael Kent Curtis, No State Shall, placed new historical information in play regarding evidence in favor of incorporation. I've been significantly influenced by work that Michael really did. Then Akil Amar really built on what Michael had done and wrote his book on the creation and reconstruction of the Bill of Rights. And I think those two books, Michael's book and Akil's book, really form the foundation for any argument in favor of incorporation, and it's largely influenced mine as well. So what evidence will you find if you go to those books? You'll find evidence that the man who framed the Privileges or Immunities Clause, John Bingham, publicly announced in speeches published in newspapers that his efforts in those early months of 1866 were to produce an amendment that would require the states to enforce the Bill of Rights, and he used language involving privileges or immunities in his first draft. The language changed a little bit by the final draft, but then during ratification, he continued to give public speeches saying, hey, what I drafted, it's going to apply the Bill of Rights against the states. And then later on in 1871, he said, that amendment that we just ratified, it applies the Bill of Rights against the states. Now, he's only one guy, but that's solid. I would cite that in a law review article. And then also, probably just as famously, Jacob Howard, a senator, introduced the Joint Committee's draft of the 14th Amendment to the Senate and described the provision drafted by John Bingham as having the effect of accomplishing the application of the first 8 amendments to the Constitution against the states. So there really are meaty clauses that I think give you a place for an originalist to hold on to in making that originalist argument. But as Julia points out, lots of people have challenged this. The article, and this is why, because this is what academics do, darn it, they challenge, okay? And then you have to respond to them. The article that I'm publishing in the Virginia Law Review, I should not have had to spend my time on, okay? I had better things to do. You know what it says? The article says, the Bill of Rights, it means the Bill of Rights. And if you look historically, they thought the Bill of Rights meant the Bill of Rights. Why should I have to write that article? It's because about 5 years ago, maybe 10 years ago now, a few academics began to make the claim that when John Bingham used the term Bill of Rights, he did not mean, or we can't know whether or not he was referring to the first 10 amendments to the Constitution. He might have been referring to the Declaration of Independence. He might have been referring to common law liberties. The term Bill of Rights didn't take on its modern meaning as a reference to the first 10 amendments until the time of the New Deal. And this Gerard Maglioka wrote a book along those lines. Randy Barnett picked up on that argument. A number of people, and I think that I think Stanford's Guy Knapp has gone that route, and I think Judd Campbell has started to cite it as well. And this made no sense to me at all, spending most of my time in abolitionist history. I knew that when they used the term Bill of Rights, that they were referring to freedom of speech, freedom of religion. It was part of the abolitionist doctrine at that time. So, but they were gaining steam for this new and radical idea that the Bill of Rights didn't really mean the Bill of Rights. So I had to do the empirical work that nobody thought needed to be done to actually provide specific examples over 70 years of this common use of the term Bill of Rights. So each generation is going to be challenged. Each claim is going to be challenged, and originalists always have to be ready to answer that challenge. So again, that's a kind of a long answer. I think there's evidence there. The debates will not stop because this is what academics do. It's very Oedipal, right? We always try to slay the generation before us. And so that's why the argument is going to continue. But nevertheless, I think at this point, justices feel justified in accepting this historical record. So I think.
Yes, so I don't disagree that academics will continue to quarrel. And I would never, ever want to underestimate what has been called the narcissism of small differences when we are looking at the academy and so forth, because even if there is not a big thing to disagree about, something will be found. As you say, this is in part the incentives of academia are set up this way. But I would say a lot of these differences are, to me, not minor, and and again, I'm not suggesting that history is useless. I'm not suggesting that the work of all these scholars who we have been discussing is not extremely valuable. I think it's valuable for any citizen, in addition to other academics, of course, but valuable for any citizen who wishes to understand the United States better, for anyone in the world who wishes to understand the United States better, potential citizens maybe, and so forth. Absolutely spectacular. But in terms of giving answers, it is of limited use. I don't say no use. Again, I'm only asking to be that we all be realistic. And also to think about the fact that even where history is not generating answers, which is what most of those or many academics who are embroiled in these discussions are looking for answers, arguing that they have provided answers, explaining why the academics who are questioning their answers are wrong. That's a perfectly fine thing to do, and your project sounds very worthy, and I look forward to reading it. At the same time, history can do more. And if history is thought about on a more broad level, it doesn't immediately devolve, I think, into just being used opportunistically. I think that it can be used in a way that is principled and a way that is helpful. Even if history is not providing specific answers, I think it can provide guidance. An example of this is the Supreme Court's recent unanimous opinion in the Fifth Amendment case, Tyler v. Hennepin County, handed down last June, May, where they find that a home equity theft law, as they called it, as the challengers called it, obviously. The state of Minnesota didn't call it that. But the challengers called it a home equity theft law that provided that in the event someone doesn't pay property taxes and doesn't pay property taxes and doesn't pay property taxes and doesn't take advantage of opportunities to pay off everything owed, property taxes plus fines, et cetera, at some point the state can take the property, sell it, and keep all the proceeds. Not just the amount of money owed to the state, but keep all the proceeds from the sale.
For their trouble.
Okay, right. It sounds bad, but on the other hand, was this a case where the state of Minnesota had just suddenly passed the statute and everyone gasped in horror, and then the Supreme Court immediately stepped in and said, no, we don't do things like that? No. The fact is that although it was a minority rule, this kind of statute providing for the state keeping all the proceeds of property sold for non-payment of taxes, and not simply keeping the money that was owed to the state in unpaid taxes and follow-on fees, penalties, etc., but having to return the surplus to the owner of the property who had lost the property because of not paying taxes. About 8 states, maybe 10, and the District of Columbia had similar statutes. And these statutes, Minnesota's in its current form, was pretty much dated to, roughly speaking, the New Deal era. Others of the statutes had come in the New Deal and maybe a little later, but even before the New Deal era, we could detect the vestiges of such statutes, or the precursors, we could call them. This was not an entirely new idea. Was it a common practice? It was not, but we had it. So how can a unanimous Supreme Court get to the point of saying, this is wrong, this is unconstitutional, and so forth? They, I think, use history as guidance, and even a little bit history as inspiration, frankly, because they are saying, going back to the Magna Carta and looking at big principles and principles of the importance of property ownership for many reasons, autonomy and liberty and a well-functioning polity, and looking at the dangers of government abuse. This is history on a very high level. Now, detractors, although there haven't been many detractors to Tyler v. Hennepin County, which I'm a little disappointed by because I'm writing on it. And it's always interesting to be able to get some, right, to have some detractors to explain why they're wrong, right? As you say, it's what academics do. But if I have to play devil's advocate, another important job, which is part of the job of an academic, I would say, wait a minute, maybe these aren't great. We can see why they have been unpopular in the sense that it's been a minority rule, in the sense that most states will return the surplus to the property owner and not keep it, but some keep the surplus. But it's not unheard of, and if we're going to get granular, if we're going to really get into the weeds of this, we find that there have been different rules and that they've all been considered to be legitimate. How is it that something can become illegitimate over time without a formal constitutional amendment? I think those who interpret and construct the Constitution have to give a good answer to that question. And I think the answer is, to some extent, or at least a piece of this puzzle, is the effective use of history as a form of guidance.
I love that point. And if I can build on it just a little bit, because it takes me to that idea of not only history as guidance, but also history as inspiration, talking about going back into time immemorial. This is part of our DNA, that kind of thing. One of the more, something I learned back in law school that had an enormous impact on me was reading the work of Hannah Arendt. And this was in Bruce Ackerman's class on constitutional deliberation. And the idea being that the meaning of the word revolutionary and revolution, it means to revolve. It means to go back to the beginning. And successful revolutionaries almost always justify the revolution not as a beginning of year zero. You do find year zero revolutions, but more often you have a revolutionary calling the populace back to themselves, back to who we are as a people. So it's a seek to return to the beginning, and this is a use of history as inspiration, and it very much was a part of abolitionist rhetoric. That there was a debate about slavery, and the northern abolitionists were calling on the country to return to their roots and return to the Declaration of Independence, that's who we were. And that all men were created equal, and that the founders, although they acquiesced to Southern slavery, the founders themselves were committed to the principles of the Declaration, and that's why they passed the Northwest Ordinance, even before the adoption of the Constitution. So they were using this argument of history as inspiration to call the people back to something more foundational as a matter of aspiration. And so if you want to understand constitutional rhetoric, the call for constitutional claims, you hear its echo in these uses of history as inspiration. I think the book that I'm writing right now for Yale University Press is going to be about the adoption of the 13th, 14th, and 15th Amendments, but it's not going to be about doctrine. It's going to be about the event itself, because I think we should look at the adoption of the 13th, 14th, and 15th Amendment as an incredibly inspirational moment. None of those amendments were necessarily going to be passed, and the people who devoted so much of their lives, blood and treasure, as well as their lives and families, to try and push through these ideals, and they succeeded. And one of the greatest moments that I really think should be celebrated by the United States, 14th Amendment Day, the southern states in the beginning were set up, you had provisional governments right after the Civil War, and these white provisional governments set up by President Andrew Johnson didn't want to ratify the 14th Amendment. So Congress said, well, okay, maybe we want to hear from everybody in the South. They directed the military to register all loyal citizens in the South, including black Americans, and give them a chance to decide whether or not to create new constitutions, and if they created a new constitution, to decide whether or not to vote for new governments under those constitutions, and those new governments could then vote on whether or not they wanted to ratify the 14th Amendment. Well, sure enough, black Americans in the South did want new constitutions, they did want new governments, and in South Carolina, in the middle of the summer of 1868, voted in favor of the 14th Amendment in a majority black assembly. The state that had started the Civil War was now under the control of African Americans, and this incredible turning, right? This incredible revolution that's part of our American history. That history and what was possible and what was proven possible at that time, I think, should be part of our constitutional memory and should be viewed as inspirational.
Great. Well, thank you so much. And at this point, we have a couple minutes left, so we can open it up for audience questions if anyone would like to ask our speakers. Yeah.
Right. You have, well, it's a great question, and it's going to be different depending upon which provision that you're talking about, and what role that provision had played during the struggle over slavery between the time of the founding and the Civil War. Some were wholesale changes, very large theoretical changes where a Bill of Rights that once represented federalism and states' rights now was viewed as a declaration of individual liberty. That all by itself has enormous doctrinal implications without even going any further. I think it has enormous doctrinal implications for the Establishment Clause. I don't know if one of the arguments about the Establishment Clause is it doesn't say Congress shall not establish religion. It says Congress shall make no law respecting an establishment of religion. And I agreed with Akil and others who have argued that that language was meant to be state protective. It was meant to say, federal government, we're not saying establishments are good or bad, we're saying you stay out of it. And you can neither establish religion in the states nor disestablish religion in the states. So it was completely agnostic on whether or not establishments were good or bad. I think the evidence is that that changed. Once you view the whole Bill of Rights as something that can be applied against the states, you by definition are taking a new understanding of the Establishment Clause, because now you must have some kind of idea that it's saying something that can be applicable against the states. That's evidence of changed meaning. Well, what's the change? I don't know, let's study. We've started high, and we now know there's been some type of shift. but did they shift in the direction of Jefferson's separation of church and state? Did they shift towards Madison or what? We don't know. We have more work to do. But we do know something has changed. Michael Kent Curtis has done similar work on the freedom of speech clause. And it's a wonderful, very dense book, but a wonderful book of the People's Darling Privilege, where he does empirical investigation of people's idea of the term freedom of speech in the First Amendment and how that was understood at the time of the founding, but how the struggles over slavery changed it into a far more robust libertarian right to engage in inflammatory speech. Something which Judd Campbell, I think, has proven was not the understanding of that phrase at the time of the founding. Judd thinks the Alien and Sedition Acts were perfectly constitutional. We didn't have a robust idea of freedom of speech at that time. But I think that if you study the empirical evidence, you might, and I think Michael Curtis has, and I agree with him, but we can talk about that. You can find those same words being used in ways that are a flip, are significantly different from how they were engaged at the time of the founding. Can you do this for every clause? I'm co-authoring a piece with Stephanie Barclay right now on the free exercise of religion clause, and we're making a similar argument there that when they viewed those words, they didn't view them in terms of Jefferson or Madison or colonial days. Republicans viewed those words in light of Uncle Tom's Cabin and resistance against the fugitive slave clause and the right of Christians, the fundamental right of Christians to provide a crust of bread for the needy at your door, and that this was a religious right that was part, and they said so, they actually said so. This is part of our free exercise of religion. So it's our burden to see if we can find enough evidence to make a convincing case where we have evidence of this understanding at the founding, and then we'd have to have enough evidence to convince people that there's been some type of change. So we would bear the empirical burden there, and we might not get there. We need to be realistic about what we can find, but I think it would be a gain to even get the issue on the table that something might have changed. That in itself would make me happy on a given Tuesday.
Any other questions?
So I think primarily for Professor Mahoney, thank you both, by the way, for your presentations today. The idea that I thought of when you were speaking about what history can give us is the idea of certainty, and insofar as is that even a realistic thing to be looking for when answering some of these larger questions? Because I understand your point is that history can't necessarily give us the answers, and we end up with major divisions, but it can give us guidance. So to what extent can we realistically even look for certainty to answering some of these questions, whether we're using history or some other interpretive technique? And at what point should we be satisfied if we answer the question sufficiently?
It depends on the question. History can give us some pretty specific answers for some questions about our Constitution, but I don't think it can give us dispositive answers about all of them. It can, so I think it is, the Constitution was, of course, crafted in part to return. The Revolution was fought by those who thought their rights as Englishmen were being abrogated, that the tyranny was coming down hard on them because those who ran the British Empire had departed from core principles. But at the same time, too, our founding generation did understand that they were, in a sense, making the world anew. It is hard to exaggerate how confident they were. They were young, they were energetic, and they knew that they were doing something new. And they believed that the eyes of history were upon them, whether or not people can govern themselves or not. That is the question that our Constitution will answer, in effect, was said, I think, in the first Federalist paper. That remains with us today. So I feel like we hand it all over to you all now, right, to take this a bit further.
It's a republic if you can keep it.
Precisely.
All right, any other questions?
Yeah, quick follow-up on that. Professor Mahoney, I am sympathetic to the idea that sometimes it seems like history just doesn't give us enough to get to an answer that we can really be confident on, especially when you have a case in front of you and you need a really pretty specific answer. Obviously, throughout the symposium, we've been talking about the role of tradition and what the post-ratification understandings and practices have been on a specific issue. Are you comfortable with what do you think should, obviously, you need to come up with an answer on a lot of these questions. So what fills in the gap when history was done?
Yes, I don't have strong views about this. I do think that as a practical matter, that tradition rarely provides specific persuasive answers where where text does not, where text and history, for example, do not. So, and I would argue that tradition tends to be more helpful in the history as guidance box. What do you think?
Well, it depends. You're in the construction zone, right? Meaning is run out. History has only taken you so far. Maybe doctrine is only, maybe stare decisis, precedent has only taken you so far. And you've still not arrived at how this particular case has to be decided. And so in the construction zone, you have lots of different theories that could be applied. And even for originalists, we would come to different conclusions about what to do at that point. Some originalists accept constitutional stare decisis, some do not. Some are originalists because they have certain libertarian theories of human flourishing. And so they would put their thumb on the scales of filling the construction zone with applications that advance that particular libertarian theory. Others are natural law theorists. I'm a popular sovereignty originalist, which means that I feel that my thumb on the scales is to leave matters in the political process unless there's sufficient evidence to believe that the people meant to remove it from the political process. And so you fill it in according to your normative theory, and that answer will be different depending upon why you're engaged in this effort to begin with. And I have no problem with that. That places the burden on all of us to try and evangelize, to try and explain why our way of filling in the theory advances the best normative theory of the Constitution.
All righty, thank you so much. And everyone, please join me in thanking our speakers.
Have fun.
Thank you all. And thank you to our speakers, Professors Mahoney and Lash, for joining us. That was wonderful to hear. That concludes the 5th Annual Originalism Symposium. Thank you all for attending. Thank you to all of our speakers throughout today for bringing life to these debates. It's been a pleasure planning and executing this event, and look forward to seeing many of you this evening at the spring banquet. Happy Friday. Have a great day.
Great. Thank you. It's my